Now the issue that we came across about 5 years ago, and that we call our Kids Protection Plan, what it does specifically is, in 15 years of planning before we started doing the Kids Protection Plan, working with families with young children, we always addressed the issue of what would happen to your kids if mom and dad did not make it home. From date night out to dinner, what would happen to the kids if you didn't make it home? And that issue, principally from an estate planner standpoint, was dealt with by long-term guardians. Who would we name to take care of our kids if we were not able to? What we never addressed before, and what the Kids Protection Plan really addresses specifically, is what happens to your children if something happens to you and before the formal guardian is appointed by the court. Because that's a process, that's a court process. If something happens to mom and dad, I may have named a formal guardian ultimately to take care of my kids, but there could be a several month gap, period of time, before I don't make it home and that formal guardian is appointed for my kids. So what the Kids Protection Plan is designed to do, and Christy will talk about this in a lot more detail, is to fill that gap. Now, as I said, I started estate planning 22 years ago in a big law firm, downtown Phoenix. And in that environment, we did estate planning like lawyers do in big firms, which is, it's a very transactional approach. We would sit down with a family, we would spend an hour, hour and a half with them maybe, trying to figure out what form we would plug them into. Family would come back, they'd sign up the paperwork, we'd give them, here's your estate plan. They'd walk out the door, and we'd never see them again. Or rarely would we see again that family. Well, that plan ultimately is not going to work when it's needed. It's not going to work when mom or dad becomes incapacitated. It's not going to work if mom or dad die. Because what happens to that plan? It sits on a shelf gathering dust for years, 15 years, 20 years. And then when it's needed, it fails because it's never been updated to address changing circumstances. Right? Family circumstances change, finances change, the law changes. And those plans that are not updated and maintained over time fail completely. Well, in our practice, one of the things I always wanted to do, my goal when I set out to form my own firm 13 years ago, was to make sure that we had a much more relationship-driven practice with clients. That clients knew who we were and we knew who they were. That we spent the time that was needed to really get to know a family, to understand their issues, their fears, their concerns, their children, all of the dynamics that make up a family and extended family. Because that's really the only way that you can do good, effective estate planning. I get the question from time to time, well, why can't I go on LegalZoom or go on the internet and download a will? Sure, you can do that. And it's cheap to do, it's inexpensive to do, and it's not going to work. Because it's a form that you plug in some gaps, you fill in some blanks, and maybe it fits your family a little bit, but ultimately it doesn't. And what it really doesn't do is, doesn't address the things you don't know. We never know what we don't know. And there's so many things I don't know. At least this is one area that I do know some things. And when you try to do it yourself, estate planning, again, those plans aren't going to work just as well as the plans that sit on the shelf for 20 years aren't going to work. So in our practice, we've got mechanisms set up to make sure that we stay in contact with our clients over time, that we have formal meetings to update and maintain plans over time. So in a little while, we'll talk a little bit more about some of the differences between the way we in particular do things and most planners do things, and certainly the way I used to do things in a big law firm.